Hey everybody, Attorney Lacy Thompson, and like I said, I'm out of the Columbia office, and I wanted to talk about post-conviction relief, or as we shorten it to PCR cases. We do take PCR cases, post-conviction relief, and so what does that mean? Post-conviction relief is something we have to file timely, first off. Okay, so we get calls from people who've been convicted of crimes, whether through a trial or they've pled, and they're wondering, can they get out? Is there any issues with appeal? What about PCR? First off, PCR has to be filed within 1 year of when your appeal is done, if you do appeal, or 1 year from someone's conviction date if they choose not to appeal, or 1 year from post-trial motions if there are any. So for the most part, it's 1 year. And we can help you if you call in and you're asking about a loved one who's incarcerated, whether or not they have grounds for post-conviction relief, and inquiring about our firm's services. The first thing we're going to look at is, are we still in time to file for post-conviction relief? So we'll look at what's called C-Track online to see if there's an appeal filed. We'll look on the index to see when the conviction date was, so that way we can make sure that that is filed within 1 year, because that is the statute of limitations on post-conviction relief. Post-conviction relief is also the only case we technically do that's civil. So we say we only practice criminal defense. That is true because post-conviction relief is mainly criminal defense based, but it is technically filed in common pleas. It is technically a lawsuit against the state, stating that the state should not have convicted you for your crime, essentially, and here's why. So there's two ways to get post-conviction relief. One is newly discovered evidence. I've never had that. It's been 10 years. I've never seen newly discovered evidence come up, and it's hard to win on that. Newly discovered evidence is also evidence that could not have been discovered at the time of the case, that the person's trial attorney could not have found at that time and has later found. While I have not handled it myself, I have seen it in somebody else's case. I have found newly discovered evidence in somebody else's case that somebody else was handling, and let that attorney know, and they put that as one of the grounds. So it does happen, but I do think it's more rare, especially in today's age where we have DNA. You do see, we've seen over the past several years as old DNA has been tested, people getting exonerated based on that testing. So that would be newly discovered evidence, and the grounds would be that DNA testing wasn't available at that specific time that this crime was committed. You just don't see that as much nowadays, because if we're within that 1 year time frame, most likely there was DNA that was tested. What we see in most of our PCR cases, or not necessarily see, but what we're looking for, the most common ground, I guess I should say, is ineffective assistance of counsel. And that means that the attorney that handled your case, whether that's your trial or your plea, was not effective. And not only do you have to show like, hey, my attorney messed up, you have to show a prejudice prong, that it prejudiced your case in some way, shape, or form. So they are tough cases to win. They're very case law specific that you have to look at. But we do handle them. We do PCR cases. Me and Laura both do them. I think I get most of them out of the Columbia office, but we work them together. We bring in often a third attorney to overlook everything as well, because we want to bring up every issue and ground that should be raised that we can find. And the essence for PCR, and the reason it was designed, was because our court system acknowledged that innocent people do get convicted. It's something that is really sad. So post-conviction relief was actually designed for people who are innocent and get convicted to bring forth the errors that convicted them to get them a new trial. And I do think sometimes judges lose sight of that, because I have seen people I truly believe are innocent. I'm firmly convinced are innocent, and their PCRs get denied. So I think that's lost with judges sometimes, that these things happen, and that's why it's designed for that purpose. But if you have a loved one, they've been convicted of a crime, you think that the trial attorney messed up on some things, and you want to talk about it and see if there's grounds, give us a call. We'd be more than happy to talk to you, look at those statute of limitations, see if we're in time to file it, and see what issues we can raise.